Yema hwefo ina kwa ba na yemfambra yem platform we eso. In fact, NPP communicator ye friend lawyer Afoakwa osanso ye NPP lawyer. Na owura we ene ne ho adi nsensemia ni na ne se o try senka oku defend afenyo marking any NPP amanyuku no. But oye bia nye ye 2 against 1. Owura ye friend Ivan Kyei Innocent. A youth activist to political analyst. Na oni NDC communicator ono nso na adwemu abobil papa ena omo eklashi owura ye frɛ no lawyer Afoakwa of NPP. Na omo ankasa ehun bibi. Omo ankasa eyeden ehun bibi ewo mo ani so. Yenko na yenko hwesa eya na se owura ne hu bibi woni ni so yenko na enkotie enkomo no se de esi koye yakoba e beto so kire wadwen e comment section. God bless you.
You can get that from Chamaun to me. Oh, maybe we should pay him a visit at Sawam.
Hey,
not easy. It is
can we deal with what's before course before we get into all of these gold stuff?
Yeah.
Quite straightforward, and I must say that it appears that some legal education has even been given through this ruling by the acting Chief Justice, because at some point, I don't know if the Chief Justice is back, because when he was leaving, Justice Pawan was appointed as the acting Chief Justice, so it's fair to call him that. What's your initial impression of what's being said? Given the fact that, if you look at what's being said, it appears that Kojo Nkrumah and its parties are being accused of not adducing a shred of evidence as to the specifics, right?
Yes.
The specifics as to what specifically the Chief Justice has done or otherwise that is proving some sort of discrimination. I think that's the biggest question facing everyone now. Anyone who might want to side with that thought.
Yes. First of all, I think the last conversation we had here the last time made it quite clear that this particular issue is straightforward. But just that it was laced with some political propaganda just to make it look viable in the eyes of the public. But if you sit down, even if you take out law and just take a commonsensical approach into the annals of this particular case, you come to the realization that the argument that was being peddled around lacked substance and weight. And I am not surprised that the Supreme Court has actually trashed this whole thing, because if you look at what the Chief Justice did, he was not in contravention with any of the established rules of engagement. He was doing his job as an administrative head of the judiciary, and such discretionary power, how it is exercised, has been outlined in the Constitution, unless it is capricious or maybe something definitive can be detected from anything of malice, anything of discrimination, anything of that sort can be identified that this act constitutes this. But until that, I am not sure he breached any of the established rules of engagement. But that was the issue of politics, because you see, to have a constitutional body that is operating, to have it stopped and going to the court to establish or to have the court to enjoint a constitutional body, the Supreme Court has over the years made it quite clear that you need to prove a hell of a reason to be able to have that particular injunction granted.
But it's not as though it's not doable.
But it's, that is why I'm saying
that was upheld even in the ruling.
Yes.
What they're asking for, what Kojo Nkrumah and the team are asking for, it's just that it's an adult's task, except to say that when you are asking for it, be sure of what you are asking.
What you're asking for. That means that you need a hell of a reason to be able to justify that, and they couldn't prove it. And you see, back to this particular whole thing, I have made it quite clear that for me, there is nothing even like legal vacation. It's a vacation for the judiciary, and from history and from tradition, if you look at how this whole arrangement started in the UK and how it is being utilized even in America, it tells you quite clear that design and the package, everything is for the judiciary, you understand, not for judges, not for lawyers. So if you're a lawyer, you only enjoy because you use the court. Aside that, if you look at the entire legal environment, there are a lot of lawyers who work within the corporate environment.
You're supported by the judgment if you say there's nothing like legal vacation.
No.
That's my contention with you.
You see,
because if you look at what the judge is saying, the judge admits that there's something, even it might be a convention, but there's something at least established as legal vacation, whatever the case.
Yes, you see, because it's a convention, I'm saying that I have an issue with the construct. It should be a judicial vacation in the sense that
not called a legal vacation.
Because
so it's for the judiciary.
Yeah, because the legal is a wider realm, and they don't take vacation. For instance, if you go to University of Ghana, the teachers are teaching with the objective of the average and the ordinary Ghanaian. Sitting here, the average person out there want criminal cases to be prosecuted expeditiously, and that has always been what is driving the average Ghanaian. So if the Chief Justice is acting in a manner that will bring certain speed and finesse to some of these things, the average Ghanaian who is supposed to support you in this particular regard will betray you, because for them, they want this justice to be kind of a speedy kind of something that will bring closure to some of these cases. And the Chief Justice has not also assigned cases to any judge. The Chief Justice has only issued a warrant to a judge to sit in a court, you understand? And if you talk about politically sensitive matters, there are several people within the NPP whose case are on vacation as well. Because if you look at this lady's case, the National Service case, it's on vacation because the judge is on vacation. If you look at Wuntumi's case, the Numiri Forest case, the judge is on vacation, and there are several other cases. This happened to be just a certain sort of a peculiar situation where the judge sitting has some of these cases on his shoulders. And he's hearing not just those cases, but hearing it together with several other cases in his court. So if you want to accuse the Chief Justice of bias, then he might have been assigned a particular judge sitting particularly for a particular case, but not any other case. So some of these things, it's impossible to go to court and convince any reasonable judge to side with you when the base argument is flawed.
Okay,
it's weak.
We'll come to the discrimination part, because the judges appear to be telling us now, or at least the judge, that there's even room for lawful discrimination, which is quite controversial, because he says that discrimination should be on certain terms. So we'll talk about that. But Kojo Nkrumah appears to be saying that, and through his lawyers, that look, the health of the individuals, you ought to be mindful of that as well. The judge answers only in two parts regarding, as you call it, judicial vacation service of officials, right? He speaks for the judges, speaks for the officers of the judiciary, but says, well, when it comes to the lawyer, the matter of your health is your personal. So Kojo has a point there, isn't it?
No, he doesn't. He hasn't, because you see, when Chachichi Kata went to court, I think somewhere 2008, it was 2008, and his counsel wasn't around. Then he spoke to the judge that my lawyer is not here, so if you at least can break, and when he comes back, he told him that the constitutional guarantee that you have a right to a lawyer doesn't say you have a right to a particular lawyer. There are a lot of lawyers out there. You yourself, you're a lawyer, you can defend yourself.
But I want a specific lawyer to represent me in a case. No, you're saying his health doesn't matter?
No, it does. But the thing is that if we are to go by that particular arrangement, then everybody will find an excuse and then sit home.
No, but it's because the administration of that justice is happening within a period known conventionally for vacation.
But you know very well.
Do you know why I'm saying that? So take Godfred Dami for instance. This is by no means, quote and unquote, a small lawyer, right? This is the former Attorney General that we are talking about. If I want to have him as my lawyer, because of the kind of experience, finesse he has, you're telling me that, well, you don't really care about his health. So even when he says, well, there's legal vacation, Atachia, perfect case. When he says, oh, I'm stressed, mentally stressed, I need some time. You're telling me that that lawyer, his health doesn't matter to you?
Your question will be appropriate if the court has any way shut door to anybody who is sick. Because the court has also made provision. Because there are several instances people go to court and their lawyers may not be available. The judges have been granting them those opportunities. And this has happened several times. You understand? So let us not sit here and seek to create a certain impression that there is a shut door, an argument the Supreme Court has shut door on. It is still an open arrangement. But what is in contention here is never about a lawyer or a solicitor who is sick. This is a general arrangement of us going for vacation, and for that particular matter, the whole thing should stop. That is the point. Because you see, in the previous arrangement that the Chief Justice used to assign people to go, people were being represented by lawyers. You understand? Did anybody complain? There are instances, this gentleman, Kojo Nkrumah, the former AG, there have been instances he has represented people during vacations. You understand? So the principles must be, there must be a certain established universal position
Yeah.
that this is what we are arguing from. But you can't be shifting goalposts when you sit
I'm asking you for that is, the judge does not side with you, at least it's not stated in the judgment that the legal vacation is just for judges. That's been your argument.
Yeah,
so if we are premising if we are premising the assumptions on your foundation, then that will hold to say that, well, after all, it's not yours.
Yes.
It's when the judge goes on a break that you, the lawyer, also has a break.
Exactly.
But it's not stated explicitly.
No. But he doesn't. So he doesn't have to. He doesn't have to.
The question surrounding the health, the status of the lawyer, who's also critical in dispensation of justice, you ought to answer that question.
Now, what about the judges sitting within that period? What about their health as well?
Well, he's answered it in the ruling. And his point is that for the judges, right? And I'm just paraphrasing what's in the judgment. I don't.
Yes, I want to listen.
He says once it ends, obviously
he will go for his vacation.
He will take. That's how he answered that.
Exactly.
In the ruling.
Exactly.
But he answers for the judge, right? Because he's a judge, obviously.
Yes.
So he knows what happens when a judge sits during a vacation period. Then he answers that for the judicial service officers.
Yes.
His point is that, and this is what Justice Bond.
So by inference,
hold on. I want to establish that for you so you understand my question. For the judicial service officers, his point is that these are individuals who can take their leave at any time.
Yes.
But that would not apply to a lawyer. In other words, if a lawyer, if a judge has a warrant to sit during a legal vacation, invariably the lawyer appearing before him cannot go on break. That question is not being answered. So you get it.
Yeah,
you don't have a choice.
I get
lawyer.
it. So
why is it not
from this enumeration? What anybody can ascertain from these facts is that this whole vacation is for the judges. It is not for a private lawyer. That is the basic point.
It is tied to the lawyer.
No. It is tied. I understand you.
You don't have a choice.
It is tied because of the constant engagement you have. And don't forget that this.
So you agree that there is a legal vacation in that sense?
I'm saying that the construct is poor.
Ivan, do you see the
No. The construct is poor because it's not for judges. Because if you are to limit to lawyers who appear before court, what happens to a friend of mine who is a lawyer working for Barclays Bank on daily basis? What happens for a friend of mine who works within a corporate firm? University of Ghana lecturers who are teaching because they are lawyers.
It's about semantics.
In-house here, you have lawyers who are working. You understand? No, it's not semantics.
I'm just trying to illustrate to you that this whole concept of the legal vacation, it has a wider implication because of the link that a judge will have with a lawyer.
Exactly.
The judge, for instance, doesn't have that same effect of relations with judicial officers. Okay, so if a clerk or in one court or the other says this weekend or probably next week I will not be available for work, they might find another
substitute.
Yes, to replace.
Oh, so you have even answered the question.
But listen to my point. I'm saying that in the case of a lawyer, because the client wants a particular lawyer to represent him, he may be interested in that person.
But I think the Supreme Court has also answered that particular question.
How did they answer that? Because it says the health of the lawyer.
Right to a lawyer does not mean exclusively to a particular lawyer. There are a number of lawyers out there. You understand that?
But what's the right of the client in choosing a lawyer?
No,
I have the right to choose.
Definitely.
If my brother here sitting,
you have that is a constitutional privilege.
I feel that he's the lawyer that ought to represent me.
You have it.
Yes,
but
I have it.
In an extreme situation where the person becomes indisposed or unavailable, what if the lawyer dies? Are you going to say my lawyer has died, so I won't continue the case? Is it possible? You understand? So you see, you need to create a certain room of flexibility so that people can at least, because this is a human environment we operate in. We can't be rigid and that particular and make ourselves look like we are stone. You understand? So that flexibility is what the Supreme Court sought to apply in this particular instance. And once they are not in violation with the principles of reasoning and common sense, we can accept it. You understand that? You see, I'm saying that this whole law then found itself in a social environment, and that social environment is where you and I operate. Law must serve a purpose for this social environment. The bottom line of this whole ruling is that what is the objective of the average and the ordinary Ghanaian? It's simple as that. They want some of these things to be done, because over the years we've had this impression at the back of our mind that politicians are corrupt, this blah 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 blah. So when it comes to some of these cases, people want to see speedy trial to be able to bring some of these issues to closure so that we can all settle in our mind that it's not as if politicians are conniving and colluding with each other to ensure or to take advantage of the people. You understand? But rather, we are in a state of approaching some of these things with some speed. So that is exactly what the Supreme Court has done. And for me, like I said, all these things are just nothing but political propaganda that must be ignored, because the actors, people who stifled this particular conversation, none of them has been able to premise any of the claim that they made would justify with anything of substance that will warrant the Supreme Court to take a side. And the Supreme Court has consistently established this fundamental baseline that if you want a constitutional process that has been set in motion to be halted or to be enchanted, then you need to adduce a hell of a reason to be able to have it done.
Probably what I'll add also is that given the fact that Justice Warren says there's no specific reference that was made, and part of the reasons why he made this decision.
Yes,
it does appear to me that he's now giving an opening to Kojo Nkrumah and by extension the NPP and some of the individuals to appeal.
Oh, definitely they do have the right to appeal.
That's what I'm trying
you have a right to appeal, even if that particular point hasn't been raised by the judge. Still, you are open to. But you see, when it comes to discrimination, and I think Justice Doche has even settled this particular case when it comes to discrimination, this Article 17, blah, 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 then there is an extensive ruling on that particular one, which I don't want to veer into. But the point is that if you want to establish a point that there is certain discrimination against some individuals, you should be able to prove that particular discrimination and its impact on those individuals. But the point is that Hanan and those guys who are appearing before this particular judge, there are several other Ghanaians appearing before him. And it's not as if they are trying to do anything malicious against this client. These people these are the judges who are hearing these cases. It's not like the cases have been assigned to a new person, or the Chief Justice in his warrant stated specifically that Hanan and this person's case must be heard by this judge or that judge. It was a judge who was assigned to a case. And for me, that is the bottom line of this particular argument.
I just have to say this morning that we're joined by lawyer Afoakwa. He is with the NPP Legal Directorate. Good morning to you.
Good morning.
And it's refreshing, at least for the first time, to have him on my show. I keep calling him all the time. He won't appear on my show. I don't know what kind of offense I've committed. So maybe you're on legal vacation now, so you can attend to my invitation.
As usual.
Yeah, welcome.
Anytime you invite me, I have mentioned to you that I'm engaged one way or the other.
Yes.
But sadly,
so now you have vacation.
But we don't have vacation because, as you are clearly discussing, the apex court of the land has stated otherwise.
Otherwise.
So once the court says that
you have to show up,
we are private service providers, and that's we need to be there, and the vacation is not meant for private service providers. So it means that the court is also discriminating against its own officers.
Oh, really?
Pursuant to LI 2423.
Yes.
I think Rule 1 of LI 2423 clearly distinguishes the role of a lawyer, that you owe a duty to your clients, the court, and to the public. So this is a sacred public duty that I'm discharging this morning. Once I'm in the court, I'm an officer of the court. And once I engage with my client, I have a sacred service to provide to my client. So certainly, if the court says otherwise, then it means that the court is rendering the provision of Regulation 1 in LI 2423 null and void, because you are not seen as an officer of the court. If we are part of the court to assist the court in administering justice in accordance with law, then certainly we must be seen as part of the legal processes. And if the court is saying otherwise, that is the apex court of the land. They can err, because in many times the court has made a certain pronouncement and have come back to depart from its own previous decisions.
So something can happen. In fact, I'll tease your mind on a number of issues that have been said, but let me also acknowledge Dr. Stephen Isaka. He's a member of the NDC National Communications team. Good morning to you. My first time actually engaging you. So welcome to the program.
Thank you very much. Good morning to my colleagues.
It's good to see you. It's good to see you.
Good to be here. Look, I just think that justice was done yesterday. For me, the rule of law has no holiday, and therefore,
no holiday at all.
Absolutely. We do know that traditionally this used to be for judges, and therefore I think that lawyers should be able, like everybody else.
So let me come to lawyer Afoakwa. What are the options now left to Kojo Nkrumah and by extension the those interested within the NPP fraternity?
Yeah, certainly. Appeal or review is as of right, and certainly once they have applied for the full ruling of the court, to be able to study and to apply themselves with the grounds upon which the court made such a determination. That is the right of the client, and he has instructed his solicitors, Senior Frank Davids. They have applied for the full ruling of the court to be able to study it and make a forward determination as to whether or not they are going to appeal the decision by way of a review or whatsoever. But this is a way that we must look at it clearly. I don't understand why others think. As members of the reading community, it is inclined to say, like I mentioned earlier in my opening remarks, that we are officers of the court, and we are addressed as such as officers of the court. And even the labor provisions give, by way of leave and those, every year, you are entitled to your annual leave, which even if you discount, certainly you'll be forced to go on leave because the law mandate is a statutory provision.
Right.
And once a statute provides, why are lawyers being discriminated against that we can go on leave? Well, right from January to December, it's a full working day.
In the ruling, the justice talks about context for discrimination, if I'm getting him right, because he seems to say that what the, is it 17 and 23 seem to be saying is that there's context for discrimination. So in other words, if it's not about race, if it's not about gender, if it's not about the specifics mentioned within the said article, then you might be taking the word discrimination out of context.
You see, when you read Article 125 of the Constitution, it clearly states that justice emanates from the people. And the people of Ghana, the sovereign people of Ghana, are at best described as the justice because the power emanates from us, and we have entrusted same into the judiciary to administer on our behalf. And once they are doing that on our behalf, you see, in statutory interpretation, you are required to read the whole document as a whole. So if you pick 17 and pick other ones and leave others, then it means that you are leading to the province of absurdity.
Now, which one was left out for you? Because Kujo came with 17, 22, and 293. I guess. Yes,
that was his grounding.
So so that was the grounding. So is that not the context within which he is trying to look at this?
That was the foundation, right? And this is a constitutional court. This is a constitutional court. Right. Once it's a constitutional court, they are not restrained by giving a decision that will stand the test of time. You see, we in court or in law, we mostly refer to decisions of legal luminaries like Lord Denning, Lord Diplock, and a whole lot of people, Viscount Sankey, and those things. And their decisions have stand the test of time, because they made succinct decisions that have stand the test of time. Succinct decisions. And if we keep referring to decisions in 1800s, in our current generation, then it means that those judges were clairvoyant. They were able to read into the future, made decisions that affect the lives of the current generation. Why can't our judiciary, why can't our apex court make such determinations? Because we say...
Are you not inviting them to go beyond what's before them?
They are not stopped from going beyond what is before them. You see, we have currently departed from the purposive interpretation to statutory interpretation and constitutional interpretation to modern purposive approach. That clearly distinguishes constitutional interpretation or the Constitution as a living organism, that the Constitution is capable of growth. So if black and white states that A, B, and C, what are the current trends that interpretation should give life to the meaning of the Constitution? To ascribe certain meaning to the Constitution that will help shape societal norms and the likes. You see, if you're asking us to go on leave, I am a worker. And as a laborer, I am entitled to my annual leave. So if I decide to abandon, if lawyers decide to abandon their clients in court, then it means that we are denying clients of what? Fair legal representation. Do you get it? What becomes of, say, Abdul Hanan Alubida in court? Or say Edubuahin in court without a lawyer in these high-profile cases with enormous interest. What's
making it high profile for you?
Yeah, because of the interest of the state. Because of the strong interest of the state. How many criminal trials in this republic is directly being prosecuted by the landed attorney general? Because Article 88 grants prosecutorial powers to the attorney general. When you go to the district court, the circuit courts, it is the police prosecutors prosecuting. Even in the high courts, there are other matters running in the high courts, narcotics cases and other cases, murder cases, which are felonies.
Yes, but which are serious, grave in nature.
In terms of its nature. But the Attorney General has decided to pursue Abdul Hanan Alubida, has decided to pursue Bernard Mpibo-Siako alias Untimi, has decided to pursue Edubuahen, has decided to and this case are being directly prosecuted by the Attorney General. That should be a problem with the AG and not the courts, is it? We don't have a problem with the AG.
So why are you not having a problem with the AG?
We don't have a problem with the AG.
It is you see, seeking to say that
the shrine of justice.
CJ that has a problem.
The shrine of justice. The CJ is the guardian of the shrine of justice. And if he decides to shut the door of the shrine of justice against well-meaning, well-intended citizens whose rights must be protected, then we should not have that shrine.
In whose interest should the CJ deliver justice? You just said the people of Ghana, isn't it?
The people of Ghana.
Are the people of Ghana interested in matters relating to Galamsey?
That is why you should ask yourself. You are.
No, but I have to ask you because you have to establish that. No, I know, but no, you are Ghanaian. No, you are Ghanaian. Don't choose to be.
And I see your audience smiling when you mention the issue of Galamsey. I can see your audience smiling.
Yes, I know. Don't choose to be a existential threat. You are a citizen too.
Yes, the existential threat.
Yes.
Shaking the foundation of this beautiful republic called Ghana currently.
Yes.
Is Galamsey. Currently, our waters are gone. Our forests are gone.
Yes.
Our lands are gone. Everything of ours is going.
Right.
We have fine laws to protect it. And one beautiful thing is that governments upon governments have elevated this Galamsey issue into a securitized subject. You are international relations professional. And when you hear of securitization, you know that when government elevates a certain political issue to the level of national security and approach it differently, looking at NIMOTs and other stuff, that means that government is injecting capital to fight it. Are we fighting it as we ought to fight it?
But the securitization started even from your administration.
Absolutely. But we achieved a certain result.
Should a CJ who happens to be a public officer, that's how the judgment describes him. In whose interest should he be working? In the interest of the state or in the interest of your clients who you have private relations with?
So this is where Article 296 of the Constitution clearly triggers in. And that is a sacred injunction on the exercise of discretionary powers. That discretionary powers should not be exercised in an arbitrary or capricious manner. Discretionary powers. We are complaining about water, the degrading of our forest reserves, degrading of our farmland as a result of Galamsey. How many of these Galamsey cases are being prosecuted in a manner as we are seeing today in respect of former political appointees?
At least one has gone through.
No,
at least one has gone through. This case has gone through.
It's an impugned judgment. It's an impugned decision. If you read the judgment, yes, I was part of the lawyers that prosecuted that matter, and I can tell you that decision is a dangerous precedent that we have set for this.
Because it's impugned.
It's impugned.
Circumstantial evidence would not matter, is it?
What is circumstantial?
But that's what
what is circumstantial?
But that's what the judge relied on.
Absolutely. So that's why I say it's an impugned. Which, with respect to my lady Odriko-Kuviti, I'm not here to.
No, I get that.
But with celestial respect to her, she had it wrong.
You feel that the mathematical equation didn't?
No, she had it. She had it absolutely wrong. In as much as we respect the decision of a judicial body, properly constituted,
you still feel there's a problem.
She had it wrong.
Okay, that's aside the point.
And you brought in the issue of circumstantial evidence. This is a case where the person who was arrested, engaging in direct action of illegal mining, came to court and said that yes, I was instructed to reclaim. I was instructed to plant coconuts, of which I've planted 18,000 seedlings.
Yes, but let's not really litigate that matter. I'll just bring it. Yes, okay.
No, I'm just saying this in passing that I have done this.
Yes.
But I also mined. Did you share the process of the mining with the person who asked you, who gave you the legal entry onto the land? He said no. Who owns the equipment that were seized on the land? I own them. Whose workers were on the land? These are Kunta mining workers. Say no, they are my workers. Shared proceeds? No. benefit, no, whatsoever. And I'm asking you, Blessed, you are a Ghanaian, and you know this shared tenancy, abunu abusa, that when you give your land to somebody to cultivate, in Ebunu or Abusa, do you give the person money to go and farm? I don't know what you say. No. If you give your land to cocoa farmer, that yes, I have 10 acres, use it, cultivate cocoa. I don't know if it's Ebunu, that's shared tenancy. You divide into 2, then you choose one half. If it's Abusa, you divide into 3. Are you getting?
If you give your room to someone to stay, to live in, will you go and check the place or not?
No, we are not coming in there.
Okay.
Where you are coming?
That's why I don't want us to really get the matter. Let me just, there is
nowhere that the decision of the court, the impugned judgment of Bernard and Kibosi Akontama was grounded on whether or not the person went to the site to inspect whatever activity that was ongoing or not. But the decision is that yes, the court chose. You see, there has been a time-aged principle of law that when there is no direct evidence and where there is no corroboration with regards to accomplished testimony, you are here, the AG says that the guy entered into plea bargain with agreement.
I don't want us to really
I'm coming. Once you brought the issue of galamsey, that is where we need to expose
what's happening,
the double standards of government in this matter. Once you bring an accomplished testimony, the court has stated that they should treat the testimony of accomplished persons with caution because it must be corroborated. Who corroborated the testimony of Inkum?
But won't you be
Henry Okum?
Wouldn't be himself did, is it?
The testimony of Henry Okum. Who?
Wouldn't be himself did, isn't it?
So it means that you needed a testimony of the accused person before you can make your case. That is why we say that the case should have even been terminated at the time that we filed the submission of no case to answer.
Okay,
but that is the prosecution's case.
Answer this question for me.
So this is the injustice.
No, I get it.
That has been done to Bernard and Chibosi.
Okay, we'll wait for
an innocent person languishing in jail.
Okay, we'll wait for the appeal process that you're carrying out. I want you to answer this question so that I can bring in Dr. Isaka and then come back to Ivan. The judge is asking a question about I was going to ask you about the discrimination, right?
Yes.
What specific discrimination happened? Like what specific discrimination happened or is happening in this? Because there's no specifics as well.
Get it right that when the law is right on the enforcement of fundamental human rights of persons, and this is a public interest matter, it is not a personal matter that affords Kojo Oponkroma to discharge the burden of bringing out to the court the issue of direct infringement on a person's fundamental human right. To say that, you have been discriminated against me because I am an Ewe, or because I am an Ashanti, or because I am a Nordna, or because I am that. He went to court strictly that based on the time-aged principle of legal vacations, where the courts are enjoined to take interim proceedings with regards to bail applications, interlocutory applications that needs to be settled because of the long vacation of 2 months. There should be somebody, a guardian of the law, to be around to be able to manage these circumstances. You don't go into full trials with illegal vacations. They should tell us how many of these cases, in matters that they are quoting, it is clear from records of proceedings, I will share some with you, that even it was the lawyers that agreed that because you have reached a stage of cross-examination, you needed just 2 days. Then let's fix some 2 days within August so that you can complete. Then we can terminate and come and continue within the new term or the new legal year. Because in law, our new term or the new year, our new year begins from 1st October. That's why we hold our sacred New Year service to usher in the new year and be able to start the production. So even as far as the new year or the new term is concerned, it mostly starts within the second week in October.
All right.
So it is a result of this. So if you select that, specialized courts must sit, and because we need to get this case done by December, you have set KPIs for yourself. Abdul Hanan Alubida and others. That is why we say you are discriminating against them.
Right.
Then tell us that yes, because of the exigencies of time, we are not going on vacation, and all courts must sit. And we know that you are exercising your administrative authority. Your sacred discretion, not in arbitrary or capricious manner, but in accordance with the dictates of the Constitution.
I'll come back to you because there are a lot more questions. In fact, the judge talks about how these are all criminal matters. So maybe we'll address that next, because he spoke about that in the judgment too. That legal vacation is in respect of civil matters. So probably you might want to note that down so that you address that for me as well.
I'm happy that you are distinguishing it now.
Okay. Dr. Isaka.
Yes.
Galamsey is of national interest.
Yeah.
In fact, the AG forced himself into the matter. As in what Ghanaians would say, self-foot, right? You just want to have a take on the matter. That became critical in this case because Kojo Oponkroma and his party were of the view that this does not even concern the AG in the first place. But some way, somehow, he says, well, I represent the state, so I ought to be given appearance. Is that even well settled for you in terms of the kind of arguments we saw in that respect?
Look, I'm not a lawyer, so let me put it on record that I'm not a lawyer, and my take on this would be from a layman's point of view. But then my brother mentioned Galamsey, and that is where I'd like to sort of, he talked about Galamsey, talked about our forests being completely, overrun. Look, if any government has done anything to improve or in the fight against Galamsey, it is the NDC government, at least better than their government did. Okay, we know that before we came to power.
Are you speaking on a scientific basis?
I'll come to that. Okay. I'll give you the evidence in a minute. Before we came into power, this is my face. Have you seen it?
I've seen you.
Thank you. Yeah. Before we came into power, there were forests indeed, and I'm watching the people of Ghana. Good morning to the people of Ghana, and we'll be telling the truth and separating the noise from the truth today. Look, before we came into power, there were forests that were no-go areas in this country. Is that true or not?
Oh, that
is on record.
Yes.
Are you aware that as we speak today, 9 of those forests have been reclaimed? There were no-go areas. There were danger zones. They have been reclaimed. That is a matter of fact.
So people don't go there anymore?
Well, as far as we know, as far as at least we have claimed them back. Okay, so we would say that yes, with everything being equal, they shouldn't. But would it always be 100%? Perhaps not. There might be some who so. But yes, it's on fact that those forests have been reclaimed. That's the first one. Second one is that, look, if anybody did anything to embolden Galamseyers in this country, it was their government. It was their government that legalized mining in forest. Before they came into power, you were not allowed to mine them. They legalized it. All right. We have repealed.
They legalized what exactly?
They legalized mining in our forest, not Galamsey, but mining in our forests. Okay, remember the LI that allowed you to mine in forests.
Yeah, was that the first time? Well, because that LI has a long history.
So
if you say that
it was reiterated, it might not be factually accurate, but it made a big noise of it, and they told us there was no mining going on in Galamsey in forest by Akunta mines. We know that they were doing it. All right. Look, we have repealed that law as we speak today. Now, while that particular LI did not, in itself allow Galamsey or legalize Galamsey, what it did was to embolden Galamseyers. All right, to say that, look, if our ecological zones are go areas now, then we can mine wherever we want. So it emboldened Galamseyers. We have repealed that law as we speak today. They speak about, Galamseyers being prosecuted. That is why we have come up with the public tribunals.
Or amended?
Well, amended if you like. Actually repealed. Actually repealed. I told you, I'm not a lawyer.
Okay.
But repealed. I think it's repealed. That
repealed?
Law, I think it's amended, repealed. Case? Fine. But let me proceed.
Because I need to be sure.
I've made that abandoned to you. I'm not a lawyer.
No longer in operation.
Fantastic. So it's been repealed then. Okay. So thank you, my brother.
Is it? You have to cross.
Can I come back quickly and then we can? All right.
Fortunately, the producer was in Parliament. Okay. So you check that.
Fantastic. So we have repealed that law as we speak today. All right. Why do we have the public tribunals law as we speak today? So that we can prosecute cases of Galamsey very, very quickly. Who has kicked against the public tribunals law? They have kicked against it. All right. Under the new public tribunals law, we are saying that any Galamsey court should be prosecuted, judged, and put behind bars in 42 days. They are kicking against it as we speak now. So look, let it not be said that we are not doing anything to fight Galamsey. Proceeding from there, are you aware?
If you're giving us the impression that you've done something unprecedented, what's unprecedented in comparable terms to a government that totally shut down mining in this country?
What do you mean?
Exactly what I mean.
Yes.
Was this in 2019 or 2020 or
Yes.
I'm not too sure about the date. Yes. But I was there when the president.
And what was the result of that?
Declared that he was effectively banning artisanal mining throughout the country.
Brilliant. And
no government in this history.
And that he was trading, and that he would trade in his presidency if he failed. Did he trade it in? No, he did not. Okay, so that is that bit there.
Yeah, but he took the step.
And we are trying to, but we know that Galamsey under their watch was worse than it is today. Let me proceed. Okay. Are you aware that as we speak now, there are 4,000 excavators in Temaport. They can't clear them because we have refused to allow them to clear them until they are tracked so that we know exactly where they will be mining. Are you aware we have brought in tracking to track excavators so at any time in point we know where every excavator is? Do we know where every single one will be at the moment? Perhaps not. But have we tried? Yes, we have tried. Are you aware that under the new Mining and Minerals Act, the EPA has been empowered to be able to prosecute? They had no prosecuting teeth. They have prosecuting teeth now to be able to prosecute those who are found in our,
Okay, so how do you connect all of this to the ruling that has come?
Fantastic.
Yeah.
Well, I'm simply saying that because that is where my brother seems to have, fought most of his battle on the fact that we are not doing anything to fight galamsey, and I'm saying that we are doing something to fight galamsey. So it's a national matter. It is a national matter of importance. All right, and I was giving another one. Are you aware under the new Minerals Act we have a new sort of middle tier mining sort of, if you like, where you can mine. So we had small scale, we had large scale, but we had no middle tier. We have a medium tier.
I get that, but now. I'm saying that connect that to the case.
So yes, I will connect that to the case. So indeed, if we have over 3,000 cases in terms of galamsey, being prosecuted at the moment, why should we delay those cases? It is important that we prosecute those cases, and I think that the judge was the AG was absolutely right as Minister of Justice and Attorney General to be part of that case. And so, look, for us, he did what he had to do as a Minister of Justice. All right. So, look, we want to fight galamsey, and if allowing the courts to proceed is what makes us fight galamsey, then so shall it be. Okay,
regardless of issues, concerns of discrimination?
No. What is the discrimination? The judge himself said he didn't find any discrimination there. We can't sit here and say that those judges are handling only those particular cases in terms of Aduboahin and Hanan and so on and so forth. There are other cases they are handling. It just so happened that they were the judges chosen, and it just so happened that those judges were dealing with those cases.
You believe that?
All right. Well, of course I do believe it. We have to trust our state institutions, and I do trust our state institutions. Do you trust them or not?
There's a report, if you ask me that question, there's a report indicating that majority of Ghanaians have doubts about what happens in court and with regards to judges.
And are you aware?
So I'm just speaking. Okay. I'm just speaking as a journalist. So,
but are you aware that sort of human
that's
rights
the barometer
and the human rights indicators and so on and so forth, the credibility of the judiciary will seem to have slightly improved under our watch.
What's your reference?
Well,
what's your authority?
Well, I can't put it on top of my head.
Yeah, but because the barometer is indicating that Ghanaians do have an issue.
Which is fine, but did Ghanaians not have an issue when we had an AG phone a witness and try and temper justice from that point of view? Of course they had problems.
Yeah, but the AG belongs to, according to the Constitution, it belongs to the executive.
Yeah, but did that happen on their watch? It happened under their watch when Godfrey Damian was caught on tape, all right? Fully Japa.
No, but there's two different issues. I'm just saying that if you're referring to the judiciary and confidence in the judiciary, it will not even be my opinion will not even matter at this moment. I am saying to you that there are countless reports, successive ones, pointing to how judicial corruption has become a challenge for many Ghanaians.
And it wouldn't have been worse for us.
Yeah, so if you're asking me if I believe the court, there are grounds to doubt.
Yes.
And perhaps that may be the reason for which Kojo and Co would say, well, if you're doing this, let there be transparency, because Ghanaians have a number of questions.
And my point to you is that no AG under the NDC has ever phoned a witness, as far as we know.
Okay, but that's not the
to try and bend the truth. Without saying that is but that is part of the judiciary. Okay. Where was he going to prosecute that case? Was he going to prosecute it in your house? It was going to go to
He wouldn't, but the AG is working on the interest of that.
That is my point. That it was going to go to court. So that is the case there. But is there any wonder that any case in this country that the NPP wins, they celebrate? But any case they lose, they have a problem with? What kind of double standards is that? We were sitting here when they won the by-election. When they won the by-election in Pandai, it was not a by-election. They won the election in Pandai, and the High Court ruled that they had to be a rerun. Then the Appellate Court ruled that no, there was no need to be there was no need for a rerun. I come from Pandai, so it was of interest to me. All right, and they celebrated the same Appellate Court in the case of Sedina, and they bastardized the court and they go on demonstration. So what are you telling us? Okay, so if you have a particular political party who finds everything good about cases that are ruled in their favor and celebrate, but find cases that are not ruled in their favor, that is just not democracy in from my point of view. So look, it is the case that, in my view, that listen, justice, like I said, the rule of law has no holiday. Therefore, justice must have no holiday. Hanan and Dubois, thanks to God, have bail. So they are walking around. What about those guys in remand who have no chance for bail?
Yeah.
If this is the time they get their bail, why not? Why do you delay it? And we sit here and we complain that the wheels of justice are too slow in Ghana.
Yeah.
And yet when we want to make them faster, you complain. Of course, faster based on evidence or fueled by evidence.
So you feel that's where the challenge
is? Yes, that's where the challenge is. In any case, if you go back and look at, again, I said I'm not a lawyer. If you look at that act, we're talking about, we're throwing around Act 47. And we look at this Section 91. Ivan, help me. Is it 91?
Well, is it 70?
Is it 70?
So is it? He's talking about the rules of court.
Rules of court.
I think there's a portion
that was 47. Brilliant.
Yeah,
but we know.
But there's a portion you want to refer to.
But again, but we know the article, the Section 1, Article 1, whatever they call it, says that the Chief Justice had the power to impanel any court to sit any day.
You quoted that last.
Yeah, but it's 47, but I'm not sure which subsection.
You quoted that last.
They can sit any day, even including the weekend, if he so chooses, if the circumstances are warranted. But our friends have chosen 4, which I hear talks about, they being able to take their holiday and so on and so forth. But it should be anchored on the one. Again, I'm not a lawyer, but it is within
maybe
the
counsel
context
will
of the
come
Chief
through and help
Justice
us
to decide who and what day he chooses to sit courts. But let it not be said again. Let me reiterate that we are not fighting Galamsey. We will fight Galamsey to the teeth. And sometimes in political, narratives, what matters is the will. And the NDC has bags of will to fight Galamsey.
Maybe Lawyer Afoakwa should take note of that, and you would probably help us with the rules that was being referred to.
I'll come there, but
no, if I can just come to Ivan. And so I wanted you to note the issues.
Let Ivan take it over from me, because I wouldn't sit here for some allusions to be made. You see, when my brother was commencing his submission, he says that he's going to demystify the noise on this platform. And I respect every panel member I engage with on this platform.
I didn't mean this platform, I meant in the country. So that's what it took.
Okay, so he's giving it context.
Please. You use the word noise.
Noise.
This is a national television.
This is not a noisy place.
You can be pampered in your home. You can be pampered in your home.
Okay. But you I think he's talking about what's happening in the country.
No, but you can't call that noise.
Yeah, but some of the things you do,
you can't call that noise.
Some of the things you do in the country,
you can't call that noise.
See, some of the things you do in the country are noise.
And out of the noise, that he is taking it cool.
Yeah.
You see, when you are trusted with the responsibility of managing a state, you don't manage it with that level of arrogance and the impunity that they are discharging to us.
I'm coming. I'll give you the time.
Let me clearly respond to, because people are listening to you, people are watching.
I get that. So can you?
He mentioned that mining forest reserve started under the NPP era. That is a bare fact lie.
Okay, so let's not go into that.
Please, blessed. Let's do this.
The gold body issue.
No. Let's respond to these matters. It's for the benefit of your viewers. Your young people are here listening to you. Ghana Bauxite Company Limited has been mining in the Awaso Forest Reserve since independence. They have been there. It's a forest reserve. Adamus Resources had a mining license.
But I don't want us to shift the focus.
No, let me tell them.
So I want us to finish this legal aspect.
No. You see, you did not stop him when he was bringing these issues.
It's because you
raised. So if it's improvement, because you directed me on a certain part and I made certain responses to your issues, he has deviated the court, and I need to straighten him up because people are listening to us. There is no gainsaying that mining forest reserve started under the NPP administration. It's a palpable falsehood. Nobody should take it. He doesn't know.
Okay, all right.
Again,
can you be brief about that?
I'm being brief. He mentions that they have reclaimed forest reserves and that nobody is mining forest reserves. It is also palpable falsehood. Last week, the Forestry Commission in Western Region reported that forest reserves that declared of the illegal miner, they have returned back. They are still mining the forest reserves. 9 months have gone to the forest reserve just 2 days ago, burning excavators, other things. So mining the forest reserve is still ongoing, and that one is legalized by the state.
Right.
Again, he mentioned that the fight against illegal mining under the administration is unprecedented. It is true, I agree with him that it's unprecedented. But it is unprecedented because the state is an abettor in illegal mining. The state is abetting illegal mining.
Give us evidence.
Please.
No, please give us the evidence.
Direct him. I don't like this kind of behavior. Let's debate it for. I'm with you. Gold board is a statutory body.
Yeah, so we'll come to gold board. That's what I'm saying.
Coming. No. You said evidence.
Yeah.
Gold board is a statutory body.
So take
the responsibility of buying gold locally from responsible small-scale mining companies. Now nobody is required.
I'll give you the time.
No, if you do this and you invite me to your show, I won't come.
No, Council, what I'm telling
you. No, if you do this and you invite me to your show, I will not come.
What I'm saying,
because if you allow somebody to spill light, and I'm responding to it, and you are not allowing me, then why am I here? Wake me up early morning to come and sit here and watch somebody spill noise and make the allusion, put our unfounded.
But can you listen to me? I'm saying that I'll give you the time to respond to all of that.
So why can't I finish with it, then you can go on? Oh,
because you
don't do this. It doesn't make the program flow.
Yeah, but it's going away from what we are speaking to.
So if I may land.
Yes, just land on that.
Gold board is the only body, statutory body, tasked with the responsibility of buying gold in Ghana and selling.
Yeah.
So if illegal mining is ongoing and they can't sell their gold outside, who do they sell their gold to? They automatically sell their gold to the aggregators of gold board and they bring it to gold board. So if the state is buying illegal mining gold, if you buy a stolen item from the market and the thief is arrested and he points that you bought the product, you are arrested and charged with abetment of crime. Abetment of crime because you have assisted the commission of the crime. Why is the state silent on the issue of illegal mining as far as the purchasing of gold from illegal miners are concerned? If you don't buy the gold from the illegal miners, they will not have the opportunity, they will not have the gas to go into the field to go and mine. But because you are buying, they continue to deplete our forest reserve, they continue to degrade our water bodies, pollute them, and cause all that kind of environmental terrorism that we are observing. Again, he mentions that the some forest reserves were no-go area. 2025, just September 2025, the Konyako Waterworks was closed down for the first time in the history of the headworks. And the basis was that the waterworks has been polluted by illegal mining. Galamsey. For the first time in the history of Konyako Waterworks. In Agwanswedo and Central Region. Was there as a result of Akufo-Addo? People that are saying they are fighting illegal mining. And let me reference him. The Paprama Forest Reserve was first entered and mined by members of the NDC. The Paprama Forest Reserve.
Because
the Kobwa Forest Reserve was entered and mined by parties of the NDC.
We have a subject matter on gold board, so I believe at that point you can extensively also deal with the matters. That's why I want us to take it step by step. So don't feel that I'm cutting you short. I just want us to give context to whatever we're doing. So my next point now will be about which aspect of the Chief Justice's directive seeks to instruct the lawyers or the AG or the judges to be unlawful. I guess that's another question that was asked in the ruling by the court. So probably you want to note that so that I come to Ivan and then you address that. Then we go into gold board because that question was asked as well. Ivan, is it your suggestion based on what you've told me that the Chief Justice is not in a position to know which judge sits on which case?
No.
He's in an informed position, mind you.
You see, I think this discriminatory claim only fits the propaganda narrative. Because you see, the Chief Justice in his warrant did not assign cases. Rather, he assigned a judge to a court.
When you say that,
let me explain. Whether he may be privy to the cases or not. But
that is instructive.
The substantial part of this particular argument is that the Chief Justice, that by convention over the years, that is what they've been doing, assigning judges to court and not cases.
If you're talking about the principles of natural justice, you don't want to be in an informed position. That compromises.
It doesn't. Because he's the administrative head, seated with that particular power to exercise that particular power.
Yes.
You understand?
Yes.
So there is no argument about that particular point. But the point is that the sitting judge, is there any statutory limitation on a judge who is sitting in his own court from hearing his own case? Do you get a point?
What I'm saying
a sitting judge in his own court. I understand he can go to...
doesn't have issues with that. He has issues with the 293. The fact that you have the power to choose the judges.
Yes.
But you know these judges and the kind of cases they are sitting on, isn't it?
Exactly.
So I'm saying that invariably the Chief Justice is
who then
sitting at an informed position.
Who then should have exercised that particular discretion?
But does it not also matter to you that the kind of judge you select, Ghanaians are watching and wondering what's going on?
But you see, invariably, the judicial arm is embedded into the government architecture. You understand that?
State architecture.
State architecture.
Government.
And in this whole thing, most of these high-profile cases, the assignment and how it is assigned, definitely the Chief Justice has a hand in it. So ultimately, even before we got here, the Chief Justice was in the know. You understand? So it is inconsequential at this level, unless you want to activate a certain political propaganda just for some partisan expediency.
But can we just dismiss that?
No.
The AG is not operating from a point of informed knowledge. He knows what is going on. I mean, you can't tell me that
AG or the Chief Justice.
The Chief Justice.
Exactly.
You can't tell me that he doesn't know.
And that has always been the practice. This is not a novelty.
Okay.
So
he knows, but he's performing his duty.
But the point is that there are several other politically sensitive cases that several other judges are hearing. If it had happened that judges hearing all these cases, including the lady at National Service, what is the name?
The
Wuntumi, other cases, several other cases are in a speedy mood of trial, then this particular claim can be justified. You understand? But apart from these two individuals appearing, and apart from these few individuals, there are several of such cases which constitute part of the oral cases that are on vacation. That is the point. He who comes into equity must come with a clean hands. You understand? But the point is that if you are trying to make such a point and accusing a judge to have done something wrong, then you must be able to first establish the wrong that the Chief Justice has actually done. Because when it comes to discrimination, you need to be able to prove what exactly constitutes what you call discrimination. But in this particular instance, the Chief Justice was only assigning judges who will sit down, giving them warrant, and in hearing their cases, some of these cases are part of it. But my point is that, you see, beyond the politics, beyond the discussion, beyond everything, my problem is that what is the objective of the average Ghanaian out there? Just to ensure speedy trial of these things. The last time I told you, just imagine Hanan and other guys are coming from prison custody to attend this particular trial, and would they be pushing for a vacation for them? You understand? And because the Constitution espouses speedy trial when it comes to some of these criminal matters. You understand? So for me, until somebody can pinpoint that the Chief Justice has contravened any of the established rules of engagement, or there is any statutory prohibition that has been done, then I think this whole argument remains political argument. And we are free to make that conversation, even make the discussion better. But
did you hear from Lawyer Afoakwa when he says that it's as though the lawyers are now being excluded? The same thing.
But I have told you, there is no argument over this. From history, from tradition, this particular vacation is for judges, it's not for lawyers. That is why I expanded the realm by telling you that these are private individuals doing their own thing. You only get a call because there are a pool of lawyers clients shop from to represent them in court. But when it comes to legal environment, it's larger than the court, because there are lawyers within the corporate firm, within several other places who are working within the legal community. So you cannot use this vacation to conclusively say that the judges are on vacation, and for that matter, lawyers should go on vacation. That will break this line of reasoning. You understand? So for me, I think this whole thing, we are entitled to agree to disagree, but the fundamental point is that there has been a judicial decision on that particular matter, and I am not surprised, because last week when I came here, I told you point blank, but there is no way that the court will rule in favor of this particular matter, because the people who are pushing this particular case were unable to prove what will constitute discrimination and any wrongful act on the part of the Chief Justice. And in the exercise of that discretionary power given to the Chief Justice, was it capricious? Did he exercise it in favor of somebody? Any element of bias? None of these things has been argued. You know, when Kojo Oponkroma was given a post-ruling interview after the court, it was just the narrative that he was throwing around, the inferences and the circumlocutions did not center on any wrongful act or any prohibition that was overlooked. So for me, I think politics, you can find a lot of argument to make, but the substance of the matter is what has been given by the judge. And for me, that brings finality to this particular
because we
matter.
have Gold Board to talk about, I just do another round with Council and then Doc. Then we go into the matters of Gold Board. But probably, if you're in the audience, do you have any questions for any of them so far? Or you prefer that? Okay, yeah, you had wanted to do that. Yeah.
So, thank you very much.
Right.
My question is, anytime we talk about these legal matters, there is this question or there's this statement they make that political cases, political matters, political cases, and it refers to like 2 or 3 or 4 cases that are actually of national interest. My question is, if as a nation we are going to treat particular cases to be so-called political or special, leaving the other ones that are included not touched, would that wouldn't that affect the future implications, like the future legal system that hopefully we are?
So you feel that it shouldn't be like all cases should be treated the same, whether it's connected to politics or otherwise. That's
as far as the Constitution gives the Supreme Court or the order gives the Supreme Court that autonomy to act in that way, they should. Of course, there can also be what do you call it, reforms. I'm not sure of it though, but every institution want to do well than the previous.
Right.
And
so I believe that question is to lawyer
Afoakwa.
Yes, he's the one you're asking. Then you also have a question.
Yes, I have a question. Okay. Good morning.
Yes.
I want to understand something. The last time I checked, the history behind this legal vacation was that in the colonial era, most of the judges were white, and at a particular time they have to go back to the countries they are coming from to check on their families and other things. But I want to find out, as a state, legal vacation as we speak, is it still relevant?
Okay, do we still need it?
Do we still need it? Because I also think it also impede human rights. Because these 3 months that the judges will be on vacation, don't we think is also infringing on other people's rights?
Right.
So this is what I want.
Interesting points there. Let me just come to Lawyer Afoakwa, because you practice, so you'll be able to deal with some of these ones. Are you able to tackle the 2 questions here? Maybe we might start.
Let me start from the former. That legal vacation impedes on the rights of adults. Let's take it to a broader perspective. That annual leaves of workers, that's impact on the human rights of adults. Because if you go to an office, say the officer is on leave. Currently, I'm working on a legal matter. The court is almost set with the matter, and with a statutory body, the head of legal in that institution is on leave, and certainly I must wait for the person to return from leave. This is a statutory body. My brother mentioned that the vacation is for judges and not for lawyers.
Yes.
That is what an ordinary person will say, and that we do not need lawyers to go on leave. Lawyers are workers like any other worker in the Republic. So if all workers are entitled to annual leaves, even nurses and doctors go on leave. Judges and doctors go on leave. Even the police go on leave, don't they?
Police are not private individuals.
No. I'm asking, don't they go on leave?
They are entitled to.
They are entitled
but the manner in which they take the leave is
absolutely different. So that is why our manner that we take our leave is also different as lawyers. Judges don't go on leave for 3 months. It's 2 months. The legal vacation starts from 1st August and ends on 31st September. 30th September every year. You get it? So it's 2 months. So out of these 2 months, they work for the entire 1 year and takes 2 months of leave. And look at how judges and lawyers work. You work all day. The life of a lawyer or the life of a judge, the few things that you see them in court is different. The few hours from say 8:30 a.m. to say 2:00 p.m. is just a few ones. They continue to work in their chambers. They continue to even work in their rooms. If you come and see a judge, even sleeping or lying on the floor of his sitting room, going through documents,
the stress and everything,
reading to be able to.
But don't you have some respite if you are a lawyer appearing before a vacation judge? Because when he also goes on vacation, You have some period there to also rest if you want to.
That is why we have this. You see, let me explain this concept here. The issue of vacation is that not all judges go on vacation, because my brother mentioned, Doc mentioned that there are some people on remand who needs to be taken care of, and why should they go on remand and they remain in cell? That is why remand. If you are on remand and you want bail application is an interlocutory application. Your case has not been disposed or dispensed of.
Yet.
Bail is that you finish the court, that you appear to stand trial, and the cardinal reasons espoused by section 9656 of the Criminal Other Offences Procedure Act of 1930 is what you finish the court. And if the court is minded that yes, based on the admonitions made, based on the evidence available, when granted bail, you appear to stand trial, the court will give you bail. So bail, any court at all with jurisdiction to grant you bail can do so.
Right.
It doesn't matter who is sitting on the case. So that is why vacation judges sit to resolve interlocutory applications that we say motions and those things. The bail application is a motion.
Okay. Then let's deal with the next two.
Again,
all right.
Again, on matters of trial, vacation court, this is even virtual. I can sit in the comfort of my home or my chamber, my office. Sometimes even when I travel outside the country, I join vacation courts and make sure that my proceedings go on.
Okay.
You are not required to sit in court, except courts that do not have the connectivity as it is. But mostly all the courts, designated vacation courts in Accra, last year and those things, Amasamai and those courts, all are virtual courts that you sit virtually in the comfort of your office. And
okay, I was just going to ask you to address these two issues. One that's been making around in the public. First off, the period within which Kojo Nkrumah appears to be even filing this matter. The argument is that it's happening within a vacation period in itself. So is it not, are you not shooting yourself in the foot first of all when you do that? Then you might also want to address the second part, which has got to do with the directive, the warrant from the Chief Justice. Has he asked any judge to be unfair to any of your party members facing trial?
You see, Blessed, the period within which he filed the application, this is a public interest matter. Once a public interest matter, the court could have said that, oh, we are giving you a return date in October when the new legal year resumes. But because of the exigency of the time, the court said, and the injunction application is a motion. And vacation courts, I have stated here that vacation courts deal with applications, motions, not substantive matter. So they can defer the substantive matter to the new term. That is incumbent on the court to do so.
So that's what the judge was saying. That is just in respect of civil matters, such as what Kojo Nkrumah is doing, not criminal matters.
You see, let us get this clear. The fact that we don't have rules of procedure as far as legal vacations in criminal jurisprudence doesn't mean that criminal jurisprudence does not exist. It has been an age-old or age-long tradition. But in civil matter, my brother mentioned Act 47. We don't have Act 47, but we have the CI 47, which is the CI 47 204 as amended, has a provision for legal vacations. And under the vacation, I'm coming. Under the rules of court, it states clearly that the Chief Justice per warrant can, as the circumstances may determine. Right. So what is the exceptional circumstances in this circumstance? Because exercising that power clearly goes back to 296.
But because Galamsey is a national matter.
So which of these issues? Which of these issues that are being raised? Hanan matter is a Galamsey.
Oh, he pointed. It's not only Galamsey. He mentioned two. No, but I'm trying to say what's in the judgment. I'm not saying,
So he even expanded the fulcrum.
Yes.
Because the court has the power to do it.
Yes.
Are you getting it? But the matters, the present matters, the one handling by Godfrey Dame, they have the Hanan Alubida matter, Edubo Ahe matter, and all these matters before the court, being specialized courts, dealing with these matters. Which of these?
But that was not specifically raised before this judge. That's his point. That's the point the judge was raising. If I understand the ruling well, he's saying that you haven't brought any specific point of discrimination in these cases.
You see?
Am I not getting him right when he says that?
You don't really understand the ground.
That's what I'm saying.
In terms of the enforcement of the fundamental human rights and UCDs, it is clearly the domain of the High Court. If it affects you personally, the High Court is the forum for you to go.
Yes.
So that your human rights violations, you put that before the court for the court to determine whether it has been infringed upon. But if it affects the generality of the people, that is why if you are not affected personally, the forum is the Supreme Court. So that's why we say it's a public interest matter. That why is it that some matters are being tried in an ambulance with sirens?
Yes.
With sirens, wow, 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 as if there's no tomorrow. Why? So the court says that, now we know that we are private service providers as lawyers. Now the court, the apex court.
But you've always been.
No, now the apex court has made us know.
Yeah.
So they should also really look at their one of LI 2423, which puts us as officers of the court.
Okay.
Are you getting it?
Yeah.
So now that the decision has put us as private service providers,
all right,
then it really takes us from our role as officers of the court.
Yeah, okay. You wanted to chip in briefly.
Yes,
okay. No, he wants to chip in briefly. You want to.
You see, I think the reference the judge made in his ruling, he was only rationalizing the essence for a judge to say during trial, during vacation,
right?
And it's because there may be instances where the matters might be of national interest, but he was not making specific reference to Hanan or any other person's case. But that is in a general assertion that he was making, that these circumstances may warrant such sittings. You understand? And I am saying that if the judge is sitting, there is no statutory limitation on him to hear his own cases. You understand? And if the cases he's hearing can be justified to be discriminatory, then you need to at least be able to justify. You understand? But per this particular trial, that was not justified.
Okay. I guess that was the import of the question I was asking lawyer Afoakwa.
Let me reference his mind on this matter, that where a provision of law, where an enactment makes a provision for legal vacation, even if you don't find it in the criminal practice, the criminal procedure, you rely on that in the civil procedure.
Yes, but
so it means that no, please get it right.
No. The Chief Justice also has a discretion. That is the point that I'm making.
Why
beyond all these things.
That discretion has a connotation. It has how do we put it? There is an injunction on that there should be what exception the circumstances warrant.
Okay.
Are you getting it? So what exceptional circumstances warrant?
That is discretionary. That is discretionary.
Who determines?
Are you a lawyer?
No,
it doesn't matter. I'm
asking you. Take your time.
So hold on.
Take your time.
Hold on. He's asking
you don't arrogate to yourself.
Yes.
Absolutely. Where an enactment, we call it elements of the law of the enactment. The elements of the enactment is that you can make ABC. You remember there is the ruling in Pebu versus Attorney General number 3. States that the court should make legal service available even on weekends and holidays, where the liberty of accused persons, are. It talks about the liberty of accused persons. When somebody is in custody and the determination of the person's bail needs to be considered, even when it is holiday,
you must sit.
The court must sit. So there is a circumstance that warrants the sitting of the court because of the liberty of that person. So if during legal vacation, the Honorable Chief Justice, His Lordship, with respect to him, is asking certain courts to sit. That's why we've mentioned
courts, but judges.
It's courts.
But that's what the judgment says.
No, it's courts.
It's to a judge.
It's to a court.
Are you disagreeing with the judge?
The court is the judge's court. That's our profession. That's how we are trained.
Well, I'm just reading. You see, for us,
it is a court that is sitting.
But it's not to the judge. But that's the assertion made by the judge.
No, it is a court.
That when a warrant is given, is a warrant given to a court or the warrant is given to a judge?
The court is the judge's court.
Okay, well,
are you getting? That's why lawyers sit at the bar and they sit on the bench.
Okay,
that's why we accord them the respect that they need because they sit. This is their court.
Okay.
You see, let's point. Where an enactment like CI 47 has made a provision for legal vacation, we respect it and we have practiced this over the years.
All right.
And the circumstance that warrant the grant of a warrant for a certain court to sit to try matters in detail. This is a novelty. It's a novelty. It has never happened. It's a novelty.
How?
Because
it's a novelty.
It's a criminal matter.
Absolutely, it's a novelty, and that is why we need, and that for the Chief Justice to cure this mischief, the rules of court committee must sit
and put
in regulations that will govern this to take all of us from the realms of absurdity that we find ourselves now.
The gentleman back there was.
Absolutely, he's right. To take us away from the realms of absurdity.
You hear the element of discretion that I mentioned, and that has been satisfied by the Chief Justice. You understand? So he has done nothing wrong.
Okay, he's not. Okay,
that is to you.
Let me give.
No, he hasn't done anything wrong.
Let me give you the last thing. Then we talk about the board.
Ghana has a population of 35 odd million.
Yeah.
There are only 12,000 lawyers lawyers in this country, so don't let them dominate everything that we do in this country.
Oh, but
okay, there are only 12,000 of them. All right. Look, I think my disclaimer I put out here.
You don't want to dismiss a profession.
No, I'm not. I'm
such
not
a noble profession as law, is it?
I'm not.
Yeah, but if there are 12,000,
so
they still matter.
I think of course they do matter. Everybody matters. I think I made a disclaimer when I started that I was not a lawyer.
Yeah.
So my brother tried to score a cheap political point here by telling me that I said, LI, whatever. Look, that is why I defer to Ivan when I made that point. So I don't make an apology for that. Okay, I made that disclaimer very, very clearly. Right. But the next time you visit KNUST, see if you can find my name under the first batch of their LLB program. Okay, but I chose to go somewhere else. So look,
that's interesting.
So move on. Look, we talk about political cases. There is no political case anywhere. They are criminal cases. So are you telling me that if a politician goes to rape somebody, it's a political case? It's not. It's a criminal case. There are no political cases. We only ban that term around for the sake of convenience. So there is nothing like that. So my brother, you were absolutely right. Okay, that's the first one. Number two, are we saying that courts did not sit, vacation courts did not sit under their watch? Of course they did. Of course they did. We have a secular, council mentioned the fact that they had received a circular from Chief Justice Tokono, the Venerable, to the effect that Atufosin's trial was meant to continue in August during vacation. But then in July, that case was dismissed. So they do have those cases. That's the second one. The second one. Number three, he talks about ambulance sirens. Ambulance cases, what happened to Jachi Kwesen? Jachi Kwesen had to go to court every single day, even though he was a sitting member of parliament. So let them not even go down that route at all. Okay? Look, that's what we call them chambers. It's a chamber. So just because one particular lawyer can't go to court doesn't mean that the cases must ground to a halt. All right? You have a chamber. You have got seniors and juniors. The senior can't go, and the junior should be able to go. And the junior can go, and only the senior can handle a case. Then I think that senior hasn't done a very good job in his chambers.
You're not necessarily choosing the chambers.
Yes,
you're choosing a lawyer.
So
you're choosing a counsel.
I understand that. So if the chamber falls down and dies, the senior falls down and dies, the case grinds to a halt.
That's immaterial.
So my point is, and that is exactly my point. So my point is that if the senior can go, the junior should be able to go.
No, but you're assuming assuming that the accused will prefer that individual.
I gave you the scenario that he might die, so they might need to
replace him. When the person dies, so you have the option to then choose again. Who you prefer.
That the case needs to grind to a halt. Somebody should still be able to step in and do a very good job. But just before I land, are you aware that in this particular context, okay, we have a situation where one lawyer says, I'm not going to go to court. But then in that same week, that same lawyer who said he was not going to court went to court to seek bail for another of his clients. All right. In the case of Adubuahene, one lawyer said he wasn't going to go to court. But when it came to fighting for bail for Untumi, that same lawyer went to court in that particular case. That is hypocrisy of the highest order.
Gentlemen, let's talk about vote board now. I just want to 30 seconds. 30 seconds for each of you.
So
so that we just
again, my brother is referring to chambers. He should understand how the chamber works.
I'm a layman.
We have layman. So when you speak as a layman,
I'm a layman. That's what I said. I made the disclaimer that I was a layman.
Right. That's if chambers means that chamber, every person in the chamber can operate. In a chamber, we have office sharing arrangement in a chamber where you are independent lawyer working on your matter, but you are sharing office space with others. Right. So if it's your case, you are handling your matter as an independent person.
What about seniors and juniors then? Do we not have that? We don't have seniors and juniors.
So he's addressing that briefly. So
let him address that as well.
So okay. Yeah, he will land on that. Yeah, just land on that point.
So if you don't know, learn before you come to these platforms. And if you don't know, learn.
That's a cheap shot. I mean, we're having
that is a cheap shot. I made a disclaimer. I am not a lawyer.
No. So if I'm making my submission, you keep quiet and then you don't do that.
And then you tell me
no, you don't do that.
Let's make that point.
No, you don't do
down that route.
No, you don't do that.
And you think that with your LLB, you know more than everybody. You think that with your LLB,
you know my qualifications.
The PhD.
No, you know my qualifications.
That's why I'm called a doctor. So with your LLB,
just watch the next story about to discuss on vote boards. Let's watch the excerpts. There are the excerpts.
Own domain, 22 billion cedis. That's equivalent of the 1.7 billion US dollars in 1 year alone. Therefore, ladies and gentlemen, let's call it what it is. These losses are not bad luck. You don't trade in gold and make losses. They are not a difficult market. They expose the crass incompetence of gold boards management and misaligned policy of the government. No serious institution loses this much money by accident. This is what happens when an untouchable few are handed the nation's gold with no one watching and no one willing to ask questions. 3 million cedis, 10 million cedis, yetumi frɛ wɔ iyoko na wakɔda hɔ na yɛse fa ejapadeɛ a asomboɔ fa branse ama obe na ne go for be dia be hu si o me ba o we dia sa 22 billion losses here almost gold board aboke and then who bill ezika ben na ye de be bill.
First, nowhere in the under-referenced IMF reports is Gold Board accused by the IMF as having caused the losses reported to have been incurred by the Bank of Ghana under the domestic gold purchase program. I challenge Afenyomakin to point to any page, paragraph, sentence, phrase, or punctuation mark in the said reference reports of the IMF where the Gold Board was accused by the IMF as the entity responsible for losses incurred by the Bank of Ghana. In summary, ladies and gentlemen, what the IMF report states is that Bank of Ghana incurred losses through the sale of gold under its domestic gold purchase program of $400 million in the year 2024 and $1.7 billion in the year 2025. And that the 2025 loss of $1.7 billion was as a result of, I'm quoting the IMF verbatim, the scaling up of the domestic gold purchase program, not incompetence or mismanagement. According to the IMF, that loss was as a result of the scaling up, the expansion of the program. Afenyomakin's continuing antics, and I want you to listen to me very carefully here. Afenyomakin's continuing antics must therefore be seen for what they are: a desperate smear campaign by persons who have specialized in sophistry and political blackmail in pursuit of selfish ends. These are devious extortionists who will come at you with lies to tarnish your reputation in the hope that you will fold and settle for what they call, quote, compulsory arbitration and oil their palms. Well, this time around, they found their own target. There's been a call for a parliamentary probe, and I've already stated on public record that I'm waiting with bated breath for Afenyomakin's invitation. And I don't know why he's delaying and holding press conferences when, as minority leader, he can get the Public Accounts Committee to summon me tomorrow or today, and I will appear. I saw him dabbling in some confusion about standing orders of parliament and the fear that the majority may oppose a call for a probe into this matter. Well, I have, in all humility, reached out to the new majority leader in Parliament, Honorable James Agaga, and I've pleaded with him that even if Afenyo delays in extending this invitation, he should extend the invitation to me. And I'm ready to come tomorrow. You don't need any special motion. You don't need any special order by the speaker. Just get Public Accounts Committee to invite us and come and sit down there and come and demonstrate to the whole nation where the Gold Board made losses or how the Gold Board is to blame for losses made by another institution. We are waiting for.
Gold Board needed to penetrate the market. There were already established relationships. The Indian were providing money. The Chinese were providing equipment. The Turkish, they were all providing resources for Ghanaian miners in exchange for the gold. Now you set up a gold board and you want gold board to win the market. How do they do that? They've not offered any support.
All right, so that's Dr. Stephen Manteal also sharing his thoughts on the matter. But you heard from Sami Jemfi and the others as well. Ivan, here we are. The whole controversy around the losses becoming quite a challenge, isn't it?
Yeah, brother, I'm not sure there is any controversy because the issues are quite plain. Depending on how you approach it, because I am not sure anything has happened. You see, this whole domestic gold purchasing program initiative was launched somewhere in September 17, 2021, and it came at the back of economic hardship, difficulty, because all the fortunes were draining down. We had to resort to several other options. That was why the government of President Akufo-Addo came out with this particular initiative. At the introduction of this particular policy, the fundamental point was that this wasn't for profit, but rather it was for some policy engineering, just to ensure that we shore up our reserve and at the same time being able to get gold for oil. So at the first year, it was gold for oil initiative that was launched. And because of the arrangement and the fact that it was not meant for profit, the first year that the program was launched, which is 2022, the state incurred a loss of 74.4 million Ghana cedis. Then the following year, 2023, then the gold for reserve component came in, and then so it had two legs. We have the gold for oil and then gold for reserve. The same approach, the same phenomenon, everything happened. At the end of 2023, the state incurred a loss of 1.3 billion Ghana cedis. Blessed, I want you to take note of some of these things. So 2022, there was a loss of 74.4 million. 2023, there was a loss of 1.3 billion Ghana cedis. Okay. Then we went to...
Why are you ending at...
No, I'm making a point. You see, I just want us to understand this whole thing so that at least we can
continue
make some
the
progress.
I want you
so 2020, I have mentioned 2023. Yes. So 2024, similar arrangement, gold for oil, gold for reserve. The state incurred a loss of 5.6 billion, which translates into $400 million as reported in the recent IMF report as of 2024.
Can we talk about 2025?
Exactly. So the 2025, the same arrangement, the same modality, the same thing. Then we incurred a loss of 22 billion. 22 billion, which translates to 1.7 billion. So if you look at the trajectory,
which translates into
1.7 billion
US dollars.
Yeah. That is the 22
which
billion.
Is far more than 400 million.
Exactly.
US dollars. Okay.
Then you begin to ask yourself why this huge disparity in terms of the numbers. If you go to the IMF report, they will tell you how much gold, because the Bank of Ghana scaled up 2025 and bought more gold. So the more you buy, the more the debt will be widened. And the IMF also teased out 3 reasons for this whole debt. First one was
loss. Don't call them debt.
No, okay, the loss.
Yes.
The first reason was the rate at which Bank of Ghana was buying, because you see, if you go to the gold market, they buy at the forest blue rate. But Bank of Ghana will go and buy at the same rate, but when you are translating into your document, you have to do it at a bank reference rate, which will definitely where the losses will come. And again, Bank of Ghana's arrangement with off-takers, that comes with also some exceptions, and those are the areas. And then when the gold are bought, you know, their gold door has to be refined and then, get the purity. That also incur some expenses. So it's the confluence of all these arrangements that has given rise to the loss. So as we speak here, there is a loss that can be established. There is no debate about it.
Okay, so there's a loss.
There's a loss.
Okay.
So my point is that this whole arrangement is a Bank of Ghana's arrangement. And there is this deliberate attempt to just take the whole thing and insert it on gold board. Because gold board was only replaced with PMMC was replaced with gold board. So the same losses that PMMC was incurring in the previous years, that is the same thing Gold Board did. And the Gold Board was only acting as an intermediary. So there is a clear distinction between the operations of Sami Gyamfi's outfit, which is Gold Board, and that of Bank of Ghana's operation, which the Gold Board is only acting as an intermediary.
That is if you are looking at it in relational terms. Yeah. There are two sides of the coin.
Okay.
You just, and I was happy you brought that up.
Yes.
There's the sales part.
Yes.
There's the local or domestic trading part of it.
Yes.
Right?
Yes.
The sales part, you are giving that to Bank of Ghana.
No.
And then the losses from the Gold Board side, you are also attempting, and just hold on so that I ask the question so you come through, so that I get you clearly.
Okay.
You're also attempting to impugn that even when it comes to the domestic trading part,
yes,
Gold Board should still give their losses to Bank of Ghana.
No. You see, Bank of Ghana's gold purchasing arrangement is totally out of line of this whole conversation. Yes, they have a separate line of gold buying. What we are discussing, what is in focus here, is the facilitation by Gold Board for Bank of Ghana. That is a separate line. That is why Gold Board is able to audit its finances at the end of the year and make profit in 2025, because it's a separate line. And you see, people try to muddy the conversation. So
where's the separate line? There's a business link here we're talking about.
There is a business link because Gold Board is being financed by Bank of Ghana
the point.
To purchase gold.
Yes.
That gold is delivered to Bank of Ghana. And then
it came at a cost.
At a cost.
Yes. Yeah, who's incurring that cost?
No, I'm saying that the originator of that particular policy is Bank of Ghana. Sami Gyamfi's outfit has its own operation. No, don't confuse the issues. But Gold Board is buying gold.
Yes.
For itself.
Yes.
For its operations, which Sami Gyamfi has made profit.
Yes.
And at the same time acting.
Made profits out of what? There's a context to it.
No, the audited, you see, the audited Gold Board account by Auditor General, they had 5 billion in excess in terms of profit. And then in this particular line, in this particular arrangement with Gold Board, with Bank of Ghana, there is a loss. So you see, until you break that,
this is where a lot of people have had challenges with me throughout the week, because I've been seriously
because people are confused.
Okay, so can I explain now? Can I explain my question? Maybe people will get
I have the time.
Gold Board wasn't incorporated up until March.
Yes.
Right?
Yes.
Or April.
Yes.
Thereabout.
Yes.
Between January and April, which institution was trading in this loss?
No. You see, the point is that the PMMC's operation was inherited by Bank of Ghana.
So you're talking about inheritance?
No, I'm saying that. So if I take you back to 2022, I mentioned loss. 2023, I mentioned loss. Did anybody reference PMMC? Did anybody reference PMMC? Nobody referenced PMMC.
There's a business link. So if you're making a loss, it goes without saying that you are the one buying.
Did anybody reference PMMC? But why Gold Board now? Because Gold Board today is only a substitute.
Yes.
Working as an intermediary agent for Bank of Ghana.
If I can quote Afenyo Makin, he was express in talking about the leadership at Gold Board.
Okay.
Right?
Okay.
That includes an individual.
Yes.
And perhaps that's where Sami Gyamfi has an issue.
Yes.
But Sami Gyamfi, right? And you see, so I just want you guys to deal with it. I mean, I'm being dispassionate.
Don't worry.
The leadership includes Sami Gyamfi.
Okay.
Sami Gyamfi was initially appointed as chief executive of PMMC before Gold Board. Before Gold Board's incorporated.
Yes.
Are you telling me that he doesn't have any supervisory role over PMMC at the time?
You see, this whole operation is not within the exclusive realm of Sami Gyamfi.
I get that.
With the DDEP arrangement.
Yeah.
Because even if you read the document that has been thrown around, do you know the heading? It is lessons from Ghana's domestic gold purchase agreement by Bank of Ghana.
That process was not terminated up until March or May of this year.
So, no, I am not disconnecting.
There was a political transition.
No, I am not disconnecting. I am not disconnecting the two. I am saying that the operations as inherited was continued, and the trajectory as has been incurring the loss has been extended to this particular one. But there must be a clear distinction between what Gold Board core mandate is and its intermediary role as a buyer for Bank of Ghana. I think this explains it. There is a clear Sami Gyamfi's outfit
could have averted the losses by virtue of being CEO of PMMC, isn't it?
No. You see, that particular operation is for Bank of Ghana, because all the debt in question sits in Bank of Ghana's books.
If I give you money to purchase an item
for you,
that fiduciary role, you're playing it.
Put it this way: you give me money to go out there and buy water for you. Whatever you do with the water is your own business. That is what is happening.
But in the case of Sami Gyamfi, he's a public public officer.
Yes.
And he must be mindful of how he expends or uses state resources.
No, but they told
There's
you,
they
told you that component DDEP, I don't know, that domestic gold purchasing program, that arrangement is a policy intervention to shore up our reserve and to get more gold for export. You understand? That is separate from the operations of Sami Gyamfi's outfit.
Yes.
So he's only acting as an intermediary. That is why all the debt are sitting in the books of Bank of
Sami
Ghana.
Gyamfi said during his press briefing that the gold board should be credited for the CD stabilization.
Yes.
And I asked this question earlier this week. CD stabilization is a fiscal or macroeconomic decision which the BOG is responsible for.
Yes.
If you are claiming the credit...
No, he's not claiming the credit.
Oh,
this is the point.
I'm quoting him for you.
And he will say that because the trading that his outfit has been engaging in, when the money returns, it goes to Bank of Ghana's account. That is our international reserve. So solving it,
and gold board doesn't take any. But he says when it comes to the credit, give us the credit because we help to stabilize the CD.
The credit.
You are telling me that the credit should go back to the Bank of Ghana.
The credit is in relation with his outfit and what he does, and the return of that particular money into Bank of Ghana's.
Okay, so we should credit
Ghana's financial reserve.
So we credit Bank of Ghana.
But he's saying that his operations, distant of this domestic gold purchasing agreement, has brought in a lot of inflows. That is why I don't know whether you.
So then you cannot link it to the losses then, if it's distinct.
It's distinct because that is why Sami Gyamfi has consistently maintained that his outfit made profit. Because if the two are tied, there is no way he could break that even. It means that his operation is quite distant, and this operation has started under President Akufo-Addo's time till now. It's a separate intervention aimed at policy intervention.
He perpetuated that in 2025.
No, but I'm saying that look at the trajectory. Look at 2022.
He was appointed CEO of PMMC.
Yeah, I am not.
So don't you feel that he must account for that period?
You see, that is where the hypocrisy comes in.
Okay.
You see,
so
the hypocrisy comes in because yes, we can all sit here. I have a problem with that particular policy. Because this is a policy that has been incurring losses from 2022 to date.
Was Sami Gyamfi in a position to have stopped it if there was something problematic
because that is not his policy. That is Bank of Ghana's policy.
I see you enter into an MOU. You don't have power to stop that MOU.
You are purchasing for the person. The person says that I am not in for profit. It's for policy intervention. So if there is anybody with authority to stop that particular point, it should be Bank of Ghana. Because Sami Gyamfi is only acting as a conduit, buying the gold for you. You know, I am buying you the water.
Loss.
I'm buying you. You asked me to go and buy you water. I'm buying. You are not using it. You are still hoarding them. You have to determine that, oh, this thing is bringing me a lot of losses. So you see, the hypocrisy is where Bank of Ghana has been jumped over. And then gold board has been inserted into the frame of discussion, and Sami Gyamfi is being bastardized, being demonized, being insulted as a person. When this whole transaction started in PMMC, nobody ever referenced PMMC. Nobody ever referenced the person in charge. Rather, it was Bank of Ghana. And you can go back. Dr. Bawumia on several occasions justified those losses in 2022, 2023, 2024 because the intervention wasn't for profit. He said because at the time we were in crisis. So we can agree today that our international reserve, if you look at what the IMF said in its report, that it has doubled, and the state is hoping to get over 30 billion and over. So we can end it here and say, oh, this policy since 2022 to date has incurred a lot of losses. But let's end it. But separate it from the operations of Sami Gyamfi outfit. That one, if you see, they are making reference to IMF report. There is nothing like IMF report. IMF report reference document from here, Bank of Ghana. So it is Bank of Ghana's audited account that was used by IMF for this particular exercise.
All right. Lawyer Afoakwa, let me bring you in. The issue of losses, and of course, gold board, as you know, didn't exist until somewhere May, April. In fact, their funding came later in the year. So the CEO says, you can't bring us into this.
Yeah, so Blessed, I was on my feet making some submission before you cut me in on the office sharing arrangement and the sole source practice. Like a chamber, we have a sole source practitioner who deals with his cases solely. And we have office sharing arrangements in law firms that practice office sharing spaces. And we have fully fledged law firms with juniors and seniors who practice it. But there are certain matters that requires the direct prosecution of the senior in chamber. that if the senior in chamber elects or the client prefers the senior in chamber to lead that charge, you cannot relegate that to a junior. Maybe you are in a law firm, you have a junior who is less than 2 years in practice, and a high-profile case like what is going on that we are debating about, you leave that in the care of your junior, that your law firm will lose that brief. Certainly, because if the person feels that he wants a 1-year-old or a 2-year-old lawyer to handle that matter, there are so many within the market space, but prefers that he wants somebody with some diligent experience in terms of the practice of law to be able to serve the interest of the person. So let's get that clearly and not band-aid around as if somebody is trying to hoodwink the efforts of judicial processes in Ghana. On the issue of Gold Board and the Bank of Ghana losses, it is sad that statutory bodies sometimes approbate and reprobate. When it comes to profits, we say that, glorify us because we have helped to stabilize the city, we have helped to do this. But when there are losses, then we try to shift the goalposts and try to bring in other institutions that we feel that they have to take it. If your sole mandate is to buy gold from artisanal or small-scale mining operations in Ghana, your focus should be on that leg and nothing else. But if you rope yourself into monetary policy and fiscal policy practices in Ghana, where fiscal policy is managed by the Ministry of Finance and monetary policy is managed by the Bank of Ghana, then when there are blames, then you must also find yourself squarely to be blamed, because when the gains come, you put yourself in to be hailed and to be cherished in that manner. Who buys gold for Bank of Ghana? The domestic gold purchase program was a Bank of Ghana initiative and was being led by PMMC. At the time, PMMC was not the sole producer or the sole buyer of gold in Ghana. It was not the sole buyer of gold in Ghana. So other well-meaning companies could also have sold their gold to the Bank of Ghana and other things because they needed gold. But under our current regime, the fiscal policy or the legislation as we have it today is that Gold Board is the sole statutory body tasked with the responsibility of buying gold locally and selling it locally, or selling it internationally, both locally and internationally. So, if the Bank of Ghana, in just 1 year, fiscal year, makes losses of 22 billion, which translates into about $1.8 billion, just gold purchase program. What is the essence of the gold purchase program? And you see, people will start enumerating that in 2021, the losses were 73 million, 2022, it was this. When you lump all of these together, it does not even meet halfway the losses that were made in 2022, the gargantuan losses. You remember the Occupy Bank of Ghana demonstrations, where some words were churned out, that the governor must leave office, blah, 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 because they are making losses. What can be said about it? 22 billion in just a single year. We don't know what they are sitting on. And this is where a bird is sitting on its egg. You can't count the numbers, but even as and when the bird is still sitting on the egg, you can count the eggs under the belly of the hen. What begins that the bird is no more sitting on the egg, that you can see the eggs lying and counting them. Then it tells you that the situation will be what? Will be blown out of proportion. But for the intervention of the IMF with its Article 4 consultations that revealed this gargantuan loss of 22 billion Ghana cedis to the people of Ghana. But for this, nobody would have known this. The governor of the Bank of Ghana has made several interventions, had appeared before certain bodies to be able to account for their stewardship. But this never came up until the IMF mediations. That led to the uncovering of these 22 billion Ghana cedis. So blessed. Yeah. It is sad that you buy gold and make huge losses of this nature. And we must also state emphatically clear that the prices of gold on the world market has gone all-time high as far as the sales of gold on the world market stage is concerned. Within the last 2 years, an ounce of gold sells on the world market stage at a very, appreciating prices. Unlike at the time that Ashanti Goldfields was merged with Anglo Gold Ashanti of South Africa because we were making losses. At the time, the price of gold on the world market declined every day. Every day there was a decline, and they were making huge losses as a company. So they needed to hedge and make impact. But now, the price on the world market, we are making gains, several gains. There comes that we make purchases and make losses, and we are making all that of deductions out of this. Right. Can that justify why the Ghanaian people are not suffering? Who pays off these 22 billion Ghana cedis? These were the legitimate questions that Sami Gyamfi asked the NPP in 2024 during the Occupy Bank of Ghana demonstration. There is the Ghanaian people that are going to pay for these debts. and that they need the governor to be present to account to them. And they did for how many days? 2 weeks. 21 days or 2 weeks. That if the governor did not appear, then they will force the governor out of office. Right. That was about 9 billion. But now we're having about 22 billion. And they say we should not talk.
All right.
If you mention anything, then you are being hoodwinked. Insult and abuses. It has not been get of public office. Hold it. And I am sad that the code of conduct for public officers that His Excellency the President promulgated is not being put to judicial suit. Because for government accountability series to be reduced to bare insults in this magnitude because the people of Ghana are asking questions, it doesn't matter the status of the person who is asking the question.
All right.
But at least you are standing the steed of public office and you are delivering public service to the public good.
All right, Doc. Let me give you the final take on this because unfortunately we're running out of time.
Okay, thank you very much. Look, let me put this out there as an analogy to explain. All right, so you sell Kyei, all right, and your Kyei is premium Kyei. And to do that, you have contracted a corn miller to supply you with dough. So the corn miller's job is to buy corn, grind it, package it, and give you dough. The corn miller has delivered his dough to you, all right? You have paid him, done, sealed. He's walked away. You've taken the corn dough, turned it into Kyei, and then if you use the proceeds from the Kyei to support your family, the family here being the economy, but you made a loss. And you made a loss because you chose to be charitable. So you sold the Kyei at a discount. Or suddenly, prices of fuel wood was so high that you made a loss. Do you come and blame the corn miller? No, you don't.
In this case, a finished product.
Just 1 second.
Yeah.
In this case, in this particular case, the corn miller is Gold Board. All right. The Kyei seller is the Bank of Ghana. So what the opposition have done here is to go into your coffers and finding nothing, they have gone in to blame the corn miller for being the reason why you run your losses. What is the logic in that? It doesn't work.
The Kyei is a final product, isn't it?
The Kyei is what?
It's a final product.
Yeah,
at the end of the chain. Yeah,
at the end of the chain. But you had reached a deal with me to supply with corn meal, and you had paid me for it and have walked away. That is why my books are clean. My books have a surplus because I had done my job and you have paid me. So that chain breaks at that point.
So if you make a profit as the corn miller, are you going to take credit for the Kyei, the loss of the Kyei?
Did you tell me at the point where I delivered the goods to you that I hadn't done a good job? No, you didn't.
Yeah, but do you get my point?
Okay, which is what?
You don't take credit for the profit or otherwise of the Kyei.
Fantastic, but Gold Board has not until they said, first of all, they said Gold Board had made a loss. And when they couldn't find that in the books, and the books are clean, the facts are clear, the Auditor General is our auditor in this country. So how, a document by colonizer, how a document by colonizer, how a document by a foreign institution, all right? Yes, by Britain Woods institution, all right? It's just supposed to be more important.
But you took money from the same IMF when you needed the money. You didn't claim that the US dollar was colonial.
Which is why we don't
took the money.
We didn't, which is why we don't want to go back to him again. And that is exactly what Gold Board is for. Look, Gold Board is only 2 years old. No, less than 2 years old. If Gold Board was your baby, how old will it be?
Okay.
He will not be saying daddy. He will be trying to walk. And this same institution that is still a baby is produced all that we have today. Okay, why don't we say that, look, this baby will make mistakes. So let's prop him up.
Get that.
Let's fix
Can we clear the last one off the table before we go?
Yes.
The Auditor General, what exactly did she audit? Did she audit Gold Board or Gold Board PMMC inclusive?
I think everything within that year was audited. I remember it was never Gold.
We have to get that.
Yes, we can. I think it was entirety of the everything. One of the things they said was that
it's the entire Gold Board operation.
It's the entire Gold Board operation. I remember Gold Board itself never started its operations until quite recently. Yes. So whatever they were doing was under the domestic Gold Board.
So you agree with me? That if you're auditing Gold Board,
yes,
you wouldn't post dates.
No, but you go to when PMC 2025, which is when they actually started their operations. But listen, the point is this. The fees come from Parliament. They are not Gold Board's fees. Gold Board does not charge anybody a fee except those fees, delivered by or sort of approved by Parliament itself, of which the opposition or the macro minority was part of. So it cannot be said that Gold Board has gone and charged fees and as a result is profiteer.
See, NPP for any propaganda there, it is a 5 and 6. Debiano, omo etadi mwati asio. MPP for ayo madwin se omo nja propaganda da MPP for ayo madwin se omo de abre na bre nyina no they will lie hwe enzama lawyer Afoakwa te wo so lawyer we was a lawyer enzama lawyer Afoakwa te won ma wo keka panyini pa wo so lawyer we ko kasa na wano to de ketu abi ombeka tro say oh oye panyini onene nkasa sa oye panyini onene nkasa sa Ghana sa o kan no kra ketu kan no kra kire panyini na wozi o wanya ade wanya sei but utie Ivan Che innocent na utie lawyer Afoakwa you begin to ask yourself where did MPP go and I say how did MPP got here and I say get here how did MPP get here you see say kra no omo munye nyomo nim so munye omo enye oni political party kra no omo ni eye MPP communicator kushia o platforms fa de bi omo flow mo down na ye mi yase soro mu usu amabi na nkasa lawyer Afoakwa yo begin home na papa eye mi yapa se Solomon Usu of all time Solomon amiminim no wa mbabi enka obegin home na wati nkomo se enka na ho be kire papa and it is so sad say the MPP that we know no it has turned to enkofo a omode propaganda ene kasa MPP that mega mimi I know no it has turned to enkofo a omo enye den enyusu fact na mom they use tribal sentiments they use emotional biti se kwa me na afenyo marking say nye emotions a enka afenyo marking entimi kogina no menka se semijemfi aboka wo bra anye semijemfi ena sebi waboka Bank of Ghana eno mayo mudumudi ena sebi loss aba obia ni se udi dwanso a enye den a kabo bebom enye de obegeni something it doesn't mean say waboka we a cost enye loss o cost into MPP enim no you can see say they are losing grounds. MPP is losing their respect day in day out. Radio and TV so they do not make any good impact on their political party. They are just decreasing their number always day in day out. They be no more 80 or more than or more numbers so. And it is so sad. It is very abysmal. So be who political party be communicated is MPP. Now according radio so no who do can no dintro. Enye nwa because afenyo mark odi omonim go parliament wo sa na odi esi ne tiri so ana so odi esi ni so se obedi ntro obe propagate against this governance and it is so sad and it's so who MPP ni bi no so ti radio so ye the same thing. Don't let it be what surprise for you because that is of late that has been their tactic their tactics. Of late that has been their tactics. Beso omode dive but emfa abusia etim komo eno no meso so be kire wadwe o comment section no like na wa share na foforo enye bia hwe hanom eyo number 1 authentic platform be TV yakopon kan na onshira. God bless you. Bye bye.